Industry Daily, and we are joined by some superstars in the industry, experts in compliance, regulation, and telling you exactly what you need to do to make sure your business stays thriving as well. We're joined here, closest to me, by Jessica Arendt. She's a compliance consultant, and the hemp enchantress is how she's known. Next to her is Vanilla King. She's an independent compliance consultant. Will help you also keep your business in shape. And finally joining us on my far left is Liz Geiselman. She is the CEO of Rocky Mountain Reagents. Thank you so much to all of you for making time to share your expertise with the audience. I want to start off by talking about what you can say about your CBD product. There are kind of some rules and regulations. We kind of want to go over what you need to know to make sure you don't end up sideways with any regulators. I want to start by saying there's two big agencies we're talking about from the federal government that are going after CBD companies because of what they're saying, going after CBD. There's the FDA and there's the FTC. So I want to ask the panelists, what's the difference? And which one should you really be watching if you're making a CBD product? And I'll start closest to me with Jessica.
Well, FDA, hopefully, is this thing working? Okay. So the FDA obviously is the governing entity, if you will, over our Federal Drug Administration, and they oversee Schedule I and all of the things that we want to play with in this cannabinoid space. The FTC, however, is ancillary to that. They're the ones that come and get you on the money side. So they kind of go hand in hand, because never are you going to engage with the FDA without the FTC banging at the front door.
So I read the FDA warning letters, so that's what I'm more familiar with. But both of the organizations or agencies are watchdogs, and they are constantly looking out for what I call marketing language. So you have to really be cognizant and aware of both agencies out there.
Yeah, and so on that front, I don't know if that's on. Is that on?
Keep it down.
On that front, yes, FDA is going to be the one that comes in and looks at how you're manufacturing your product, right? That's what they really care about. How you're manufacturing, what your SFPs are, are you tracking customer complaints? All of that stuff is what the FDA is going to get you on that GMP. The FTC, on the other hand, is the one that's really going to have to come after you on the claims and if you're making medical claims or making erroneous claims about your product. The FDA will send you a warning letter. After that warning letter goes out, there are a group of attorneys in this country that watch those warning letters carefully, and you could see yourself within 10 to 15 days in a class action lawsuit for consumer protection. So that's something, when you get that FDA letter, the first thing you want to do is grab an attorney, and then the FTC will come in and they'll just look at your website and send you a fine. So just be aware of this.
Okay, to follow up, just to kind of to back up just a little bit, Liz, tell us, what is a FDA warning letter?
I'll let
Fennell's going to talk about this a lot. We're talking about what the takeaways are, but what broadly is a warning letter?
Basically, and certainly when it comes to claims, the FDA will start scouring anything on the internet, websites, videos, blogs, etc. And they're looking for disease claims that people are making on their products. And so the second you start making a disease claim, you're labeled as a drug. And then that becomes a very slippery slope of all the things that they're saying that you should be doing. And you're not, because you're not a drug. So that's what prompts a warning letter. You'll get it in the mail or email, and then you have about 15 days to respond to the warning letter. Now, there's been a lot of COVID warning letters that have gone out on claims, and on those warning letters, they're only giving you 48 hours to respond.
So I'll take this a bit further because I have created and implemented corrective action plans on those FDA warning letters. Works like this. The FDA, exactly as she described, combs everything. Social media, website content, labels, claims, reviews, any commentaries, anywhere. And they scrub for that. You get a letter that clearly outlines specifically what the infraction was against what they found out in the media and in the general space. That letter comes, you're given, as stated, a certain period of time to take that corrective action. But make no mistake, they're already setting up their own lawsuit. It costs money. You're given a period of time in which you have to administer or give back a corrective action plan, and it has to be specific to how you're going to make those corrections and prove those corrections.
Before we go on, I want to introduce Michael Minardi, attorney, smart guy, joining us to give us all his best legal advice. Although, of course, I have to say, this is not legal advice. So thank you so much for joining us. All right, to go back to Fenella. You have read just recently, I know everybody's read, but you've been going through all the warning letters that the FDA has sent to CBD manufacturers, and you have some takeaways. What folks should take away from those?
I have. So today, 28 warning letters have been issued to CBD companies. The first one started in October of 2017, and the latest one was March 22nd of this year, again, a warning letter. Now, the thing that all 28 warning letters have in common is they all start with claims. And then, as I stated before, it becomes a very slippery slope where you're misbranded, you're adulterated, and it just gets messy after that. So, yeah, they've all started with claims.
All right. I want to talk a little bit, put you right on the spot immediately, with your thoughts on the next question we're going to talk about. Some say, and I want your advice, some say that so you can't make a claim. A claim is saying you can't make a structure function claim, certainly can't say it cures cancer, can't say it does anything, or you can't even mention a disease that it might treat. That's a claim. But some folks recommend using words about temporary things like emotions or stress or a state, using words like this eases stress or this supports an uplifted mood. I want to know if you guys agree, and if you've seen anybody that does well kind of a temporary language, anything you'd advise about temporary language. What do you think?
My opinion is, number one, there's tons of companies out there, and I don't know how the FDA, they decide who to send letters to and which ones to pick up. I review websites and labels and packaging for clients all the time. I recommend, if you don't want to deal with them at all, steer away from it. I agree they're always giving you 15, 30 days to cure before they're taking any sort of action from what I've seen as far as any fines or anything. I don't know, at least from the FDA, if anybody's actually been fined yet. I know FTC has put out some fines, but so it depends on how, the potential you want. If you want to risk potentially getting a letter and having to cure it, maybe put those. But I advise my clients to stay away from it. I do suggest some of them will put links to, just generic headlines on it, links to FDA studies and stuff, so they're not actually saying anything about what the product does. They're just linking to, one of the studies that's on PubMed or something of that nature. But I say stay away from everything just to be safe and not have to worry about it. I think people who are looking for CBD products generally know what these do. And claims do go towards not only what you're putting on your website, but what reviews people may do as well. They do look at that stuff, so you have to really look at all of it and make sure that you're, I think, more cautious than not.
What's your advice?
The truth is, in my experience of corrective action, those temporary claims fall under the same guideline. You don't want to say you don't even want to call it something. So I'll give you an example. A brand that has CBN is known to make you sleep, so they call it Sleepies. Okay? That's a big no-no. No, can't call it that. Because to the FDA, you're telling them on that package, it's implied it's going to create or induce sleep. So you can't use temporary language. You can't even use suggestive language anymore. We're really getting tighter and tighter. It used to be, it may possibly, it could, it might, suggestive language. Now, that confine is getting even more narrow. We find that we can use fewer and fewer of those.
Interesting. What, you got anything to add? You seen?
So I always try to tell people, think health and wellness, not disease and sickness, and just try to separate those.
Interesting.
And then the big areas FDA certainly is looking at are things like pain, soreness, inflammation, anything that says chronic before it. Those are all kind of buzzwords that the FDA is picking up on. And I think with the whole pandemic environment that we've been going through, the FDA has really fine-tuned the art of scouring the internet. I mean, they are digging deep from what I've seen.
Yeah, and I think it's important that we know exactly what claims, right? These are medical claims. So it's not just about diseases, it's also about anxiety, reduces stress, pain, inflammation. Those are all medical claims. Even to say that it's going to increase the, collagen in your face, eliminate fine lines, all of those are medical claims. So you have to be very, very cautious about what you say in this space.
I would add to that anybody reviewing you, so somebody takes your product and says, this did that for me, is a big no-no, and they'll come after you for that as well.
I want to stay there because we're skipping around. Let's stay with there because one thing I think that seems very unfair that people don't realize testimonials are claims. Somebody you did not pay, you don't even know, can go on your website and say, oh my God, this cured my rash. And that is you, the company, liable for that claim. And so my question is, how do you guard against that? What kind do you need to hire someone to scrub your social? What do you guys suggest for making sure you don't go sideways with user testimonials that you didn't ask for? Start with you, Phil.
Yeah, absolutely. I mean, you do have to have someone be vigilant about it because these are considered claims and they will come after you for it. I think there's almost half of the letters that are about those issues address those. They look at your websites, they look at your social media, they're looking at everything. And so you really just have to be vigilant. And it's, it doesn't seem fair because it's CBD. We know it's safe. We know it's effective. We know, that no one's going to die off of it ever. But, they do not want this out there. I don't know what impact, Epidiolex has on these types of things or pharmaceutical companies. But I think they're probably part of the impetus that wants to keep that away from any CBD products. So that's who we're continuing to fight against.
Do you guys have any tips for watching your testimonials or watching your social sites?
So there are cost-effective ways to get that done. In recent history, I have created a guideline, if you will, of what you can and cannot say, and have guided companies to go and hire interns, right? You can hire a social media intern, put them on for 6 months. You're giving them career value to put on a resume. They're a college student or a high school student. And you're getting what you need out of it, somebody cheap to police that so that you're making sure that that's not up there. You can pay a compliance consultant. You can pay a marketing company. A lot of marketing companies, however, will bypass all of that and put that stuff up anyway because that's going to drive traffic to your site. And
Yeah.
They don't care. And that also puts you at risk. And you cannot throw your hands up and say, well, I didn't know it was there. I didn't know they did that. I didn't have any control over that because the FDA does not care.
Certainly testimonials that you put on your website, even though you might have not said the testimonial, you're still putting it onto your site, so you are still responsible. And my advice for social media, if somebody writes something about your product and says, hey, it cured my cancer, don't respond, don't like it, don't do any of that, because that is your company saying, yes, I agree with that. Something I just saw recently, which was in a warning letter, somebody spelled COVID incorrectly, so they called it CONID, hashtag CONID, C-O-N-I-D. FDA picked up on that. So don't try to hide things too, because they are really looking hard.
What do you think, Liz? Any advice on
Well, I think on social media and websites and those types of things, having a good security protocol on who can post on your website, and especially tagging your company in a post, those types of things, you should have access to untag yourself, where you have to review everything that's coming through on those places. The other thing I just want to mention also is influencers, right? So if an influencer mentions your product and they're working for you and they make claims, you're also responsible for what they say. So be very aware of that as well.
I want to stay down, Liz, and come this way. Talk about one specific area that we know from a bunch of consumer research about CBD and other cannabinoids that consumers, what really resonates with them, one of the biggest draws is the idea that it works naturally within the body. You hear all the time, we've all had the lecture about your endocannabinoid system and how this works with you. And I want to ask about this because the word natural, or the word all natural, can be a real red flag for all regulators. It's a tricky one. And it can draw extra scrutiny from federal regulators. So that puts CBD or cannabinoid makers, I think, in a real pickle. You know this is what resonates with consumers. You know this is what draws consumers to you. But you're not supposed to use the word natural. Anybody have thoughts on this, or seeing this as a tricky sore spot? How do you let people know this works naturally within your body, it's natural, without using that word? Anybody seen that way I do that well?
Yeah, I use the word organic.
Organic?
Or
Okay.
organically. You know, they're flagging words. It's hashtags, right? And
Oh yeah, hashtag is a claim, right?
exactly. Okay, it doesn't matter if it's sitting in your social media and it's over here and your website is over here at Mr. Minardi's. They're still tied together as far as federal government is concerned. So getting around those words, it's a thesaurus, and you got to play around with it. We use organic, grassroots. You know,
Grassroots, yeah.
you got to get clever.
Anybody else have any tips on?
Yeah, so I also, with my company, and I'm not just in cannabis, I'm also on the pharmaceutical side and food side. The FDA has very clear guidelines of definitions of words like natural, and the USDA has very specific guidelines on what you can call organic or not. The other thing that you want to watch with something that you're calling natural is, are you taking a CBD product and changing it and altering it in any way? Because now it is not natural anymore, right? So you want to be cautious about how that is going to be perceived as well. But I'd be very cautious when you're looking at anything when it comes to any of these words, because there are defined definitions for a lot of these things through the FDA on the dietary supplement side.
And is that where you'd say to look, dietary supplements versus food, or?
You cannot use dietary supplements.
But that's what I meant. That's
I
what
mean,
the kinds
the
of
regulation
regulations you
within
should
the
look
FDA.
at.
Yeah, unfortunately, I don't think there's anywhere to really look at. We are all still in a very much a learning process, I think, with all this, especially when you're dealing with FDA products. You know, technically, according to them, they're all kind of still illegal right now with CBD in them because they haven't written rules and regulations. So we are all dealing in murky waters. So the idea is to do as much as you can to stay away from getting on their radar, I think, and having people like this and us to make sure when you start, you're in compliance. Because I think that happened, and it's a great thing that a lot of mom and pops got to be able to get into the CBD industry. But I don't think they got into it with the understanding of it not being like every other product, but it's treated so differently. So it's very important to be on top of compliance and to continue to watch this, because this is like a rolling river. You know, every day, every week. You know, to me, the Kentucky Department of Agriculture, letter his general counsel opinion a week ago, and everyone's like, what? You know, he's saying Delta 8 is federally illegal. You know, how many people are selling it into Delta 8 right now? 10 states have banned it. It's a really fluid industry.
All right, I have one more question before we'll turn it to the audience for your Q&As with these experts. Just want to make sure we hit on, okay, to stay with Mr. Minardi. We've been talking about the FDA, we've been talking about the FTC, but as you know, attorneys are always looking to hold manufacturers accountable, as they should. This is not an hold people accountable when they're not following the rules or not following the law or making these dangerous claims. And we've seen right now a lot of lawsuits against CBD manufacturers, and some federal judges saying, you know what, FDA is still looking at this. we're going to hold off on deciding this lawsuit. Other judges are not taking that. So I want to ask you, Mr. Minardi, what is the kind of current state of the land in the federal courts when it comes to all this FDA, all this CBD confusion about what kind of claims you can make?
I really think it's probably going to get worse before it gets better.
Worse for manufacturers or worse?
Well,
What do you mean?
just the whole issue. I don't know worse for manufacturers or for people because there's no guidelines really for these people to have to abide by. I do see a lot more issues coming up with regards to this, and one we've been looking at, we talked about a little bit earlier, the non-detectable or zero THC issue. We had a client call us, and we're looking at whether or not we want to pursue a manufacturer for this, but she bought a non-detectable THC product. She tested positive. She got suspended from work, is now on a 3-year drug testing protocol as a result of it, and these issues I think are going to continue to come up in the legal side. And whether or not the courts, I think it depends on the judge, what part of the country you're in, and how liberal they are with regards to what they're going to do. I wish I could have answers, but
Yeah, no. And just to,
judges are chaos.
sure, yeah, right
So
now,
I do
for
think
sure.
it's going to get a lot worse.
Yeah, when we have, you can't even guess really where, we've had two different judges go two different ways, even in California. One says, let's hold off, one says, let's go. Okay, so for the consultants and for product manufacturers, what is your advice? Should you worry more about kind of the lawsuit or the FDA, or is it kind of all one kit and caboodle?
So, in my experience, I'm backed by somebody like Mr. Minardi, and I run to him for all things. He partners with me when it comes to consulting because I want to make sure that I'm operating properly. The general rule of thumb is the first thing you want to do is go read the letters. They're available online. You just Google FDA warning letter, CBD, and you'll get everything that's been printed and published from 2015 or 17 on. Every single one of those letters is very clear about what those infractions were, and they kind of sway a little differently one from the next. Those are great guidelines for what not to do. It's a nice little blueprint for you. Being one step ahead, being cognizant of your online activity, because online sales also are as important as your shelf sales. You cannot run your sales in each one of these markets or each one of these states in the same exact way. Many of these states now have distribution laws and regulations. Staying one step ahead is literally going to the FDA website, which I do every single week, and pulling all the information that I possibly can, and then states' rights. That way, you're always one step ahead and being proactive. You're not reactive. And then the general rule of thumb is creating barriers, right? More often than not, I get somebody who says to me, well, sure, I'm going to win in the courtroom, so bring it. And I'm like, you got $100,000 to start that process? It's expensive. Ask him. He's more by the hour than I am. So really, you want to create those barriers, but you just don't want to step in the muck to begin with.
Yes, my advice for companies is, number one, claims, so watch your marketing language. Number two is labeling. There's some very, good guidelines out there on labeling, what you should do, what you shouldn't do. And then the third, obviously, to me anyways, is good manufacturing practices, or GMP. And those are the orders I think you should take a look at what can really impact your industry, your company in this industry.
And I'll just say on that, which one do I fear most? The lawsuit, right? Because that's a class action lawsuit that could potentially come against your company. It could ruin you as a business. It could ruin you personally. So it's the lawsuit that you got to worry about. And the FDA warning letter is the thing that triggers the lawsuit. So that's what you should be aware of. My second fear would be the FDA auditor coming into my facility and taking up 3 days of my time. Because that is a grueling process to go through an FDA audit. So those are the things that I would kind of encourage you to work with. Have an attorney that knows the FDA warning letters and how to handle them. Make sure you've got their phone number somewhere close, because when that comes in, you're going to want to have them right next to you, right? and then have somebody in your facility who knows all the FDA kind of guidelines, and somebody scanning everything that's kind of out there on the internet, but also somebody that when that FDA inspector comes in your door, that they have everything ready to offer that person, so you're not scrambling trying to find, oh, where's this record, where's that record, oh, do I have this? You want to have those two things right there ready and available.
So I'll add to this, and I'm going to go back to the FTC part of it and the SEC. And they have started jumping in on the banking now, and we're kind of smoothing out the banking process a little bit, and we're seeing light at the end of a tunnel in an experience where for 7 years, every 6 months, you're changing up your merchant processor because they went to the wayside. It is a high-risk deal. They are now, processors, very tied into the FTC and the FDA. You will not get merchant processing if you are not compliant. And they are coming as well. So it's all starting to come together, really, industry-wide, to really get us regulated and going down this mainstream road in which we are protected. But again, it is not up to your private label company. It is not up to your production company. It is not up to that end of it. It is up to you to know the rules and the laws and operate that way.
It's a good way to end this. Oh, go
And I
ahead.
think too, once we get the testing down, because a lot of the claims and the lawsuits are in ways based on the product not having
Sure.
the milligrams that it says that it's in. So that's false advertising type thing. So I would definitely suggest double down on testing. And hopefully I think they gave until 2022 now for the labs to be DEA certified. And so we have
Yep.
some sort of more standardized testing across the board. So you can go to 2 different labs and you're going to get the same results, which doesn't really happen right now.
Yeah,
So I think that'll help iron out some of those problems with the FTC claims
absolutely.
as well.
All right, any questions? I don't want to cut it off before everybody has a chance to ask their questions of these smart experts. I don't know. Sorry,
have a
they didn't
mic
tell us.
runner?
I guess.
not.
I'm sorry. I'm not sure. I see a microphone over there. Let's hope it's on.
You want to come use this one?
Wait a minute.
There you go.
Okay.
Yeah. That's an important point, and I need to say copywriters and ad writers in this space are underpaid. So, because that's a very big challenge, so here's your advice.
Okay, will I run into consistently copy and paste issues? Because original content, yes, is becoming more and more and more difficult. I kind of err on the side of getting super creative. You can tell a story without telling a story. And I've seen it done. Is it more complicated and difficult? Absolutely. Can it read like something you've read before? Sure it can. Go look at my toothpaste, for God's sakes. They're all advertising the same exact thing in the toothpaste. I think it comes down to a matter of being creative, learning how to, listen, we have been adapting and pivoting in this industry now we're really beat up for it for about 7 years. Because every time we think we've got something down pat and we're meeting that regulation, the rules change again. You got to be really adaptable and do your best to pivot and be very creative around it. That's the best advice I can give you at this point.
And I really think, we really have to push, and legislators have been doing it, and they've been doing it through lawsuits, is push the powers that be that make these rules to get off their ass and get it done.
Amen.
And stop allowing us to act in a gray area. It's something that, the rest of the industrial world has been growing and using for years, and we're like, it's a new baby and this thing that we've never used before in our world when it was everywhere. So I think those are really the problems. So push that, and we have great legislators that are trying to do that. They've held, the FDA and tried to create legislation to push them to write these rules. And that's all we have to do is wait. And I think it continues to be a waiting game so that they can get their FDA drugs and things developed and kind of figure out what they're doing with that side. I'm really amazed that Epidiolex hasn't kind of gone after this industry a lot more. So.
Vanilla and Liz, any final thoughts on?
Well, I'd like to touch on the Epidiolex, right? So here we have a company that has taken a CBD product and they've taken it to the pharmaceutical market, right? They've done decades of work behind the scenes here in order to make sure that it hits that pharmaceutical quotient, right? So the question I get sometimes is, well, I'm selling CBD, they're selling CBD, can't I make the same claims? You can't, because the universe in which they did their different rounds of testing, they had different patients, different milligram doses, so we can't just say because this is out there, we can associate ourselves to the same claims that they have, right? When it comes to this area, dietary supplements, you still can't make claims, no matter whether it is CBD or vitamin C. You can't make claims until there's enough studies and enough research out there to actually, that this is just a known, right? Melatonin, for example, is known to be a sleep aid. There are so many studies out there that support that they can now reference back to all these studies and say, melatonin, I can make this claim because of all of these different things that have already gone through. We just don't have the research is the problem. Once we have the research to say, CBN does this, CBD does this, then we can say that in a dietary supplement. But dietary supplements just can't make medical claims either.
Any thoughts, Vanilla?
Just overall, I mean, you know, having disease claims goes across all the industries. So this year alone, there's been 170 warning letters that have been issued, and 30% of those warning letters are all claim-based warning letters. And so this goes across all the industries. People are very challenged with not saying a disease claim.
I have one final personal marketing tip, because there is a workaround there's somebody that can make disease claims, and that is journalists and the press. Now, I would encourage any client, they should know their local newspaper reporter, and if you have a customer that has a really great experience or something they want to talk about, say, you should call the newspaper. A lot of people know the CBD company Charlotte's Web. They treated this child with this intractable epilepsy, and a lot of people know this story. And they know it from the newspaper. The New York Times wrote about her, CNN talked about her. The company, Charlotte's Web, did not have to go out and say, we treated this. It's the press. So anyway, I think it costs the company nothing, and there's no case of the government going after a newspaper for saying CBD helped somebody do something. Love it. Okay, I know we're over time. I appreciate so much. Please give us a round of hand for our experts. Thank you so much for sharing your expertise with us today.
Thank you.
I go off my